Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Stephen Marso, an Iowa construction lien law expert. Today's webinar topic is everything contractors, subcontractors, and suppliers need to know about the Federal Miller Act. So without further ado, I would like to introduce the fabulous Stephen Marso.
Thanks, Jesse. Thanks, everybody listening to this. Today's presentation is on the Federal Miller Act. The last presentation I gave through SunRay was on Iowa's Little Miller Act. So this is a bit of a change to the Federal Miller Act. And during my presentation, I'll at times discuss the differences between the two. If you have any questions, you can submit them electronically. The instructions are on the slide here, and then Jesse will get those questions to me at the end of the presentation. So let's get started with the first slide. So the first question is, what is the Federal Miller Act? It's a federal statute, and it governs in summary federal construction projects, but there's some requirements that have to be met before it's triggered. One of them, it has to be a project for the construction, alteration, or repair of a public building or public work of the federal government. Now, court cases have held that federal projects that involve solely demolition do not trigger the act. If you have a project that is demolition and construction, it is triggered, and it would include and cover the demolition work, but if it's just solely demolition, it doesn't qualify. In contrast, the Iowa Little Miller Act does not have that demolition exclusion, so that's one difference. Another requirement to trigger the statute is the contract amount must exceed $150,000. Now, the act, if you look at the act, it actually says $100,000, but there's some regulatory increases that have been made that aren't in the actual statute. That have increased it to $150,000 for inflation. And then the third requirement is the United States or an agency or entity of the United States are acting for it has to be a party to the contract. So if those three requirements are met, then the Miller Act is triggered. Next slide. So one of the main thing, I guess, the Miller Act does for purposes of our discussion today is it has bond requirements of the prime contractor. And it requires the prime contractor to post both performance bond and a payment bond. And we'll discuss each of those in a little more detail here. Next slide. Okay, on the performance bond, what it does and what it must do according to the statute, it has to guarantee that the prime contractor will perform the project per the contract. That's the main thing it does. It protects the government to make sure that the contract's going to get performed. And then second, it covers payment of employee wage taxes. So those are the two main things. Now, there is a caveat. The federal government contracting officer can require additional performance bonds or other security beyond that required by the act. Typically, depending on the specific agency you're dealing with, they will have oftentimes written policies and things that will address those issues. So if you're on a specific project, you might take a look at what might be posted to their protocols for what additional bond requirements they might provide. Next slide. Now, the amount of the performance bond is not specified in the act, so you're not going to find how much the bond has to be for, but it does require that it be in an amount the officer considers adequate for the protection of the government. So again, you're going to have to go to that specific agency and see what they provide, and then obviously, the contracting officer is going to determine what that amount is. Next slide. Okay, now we're going to shift from performance bond to a payment bond, which is, and today we're going to discuss mainly the payment bond related issues. The payment bond guarantees payment to essentially subcontractors, those furnishing labor material under a prime contractor. And the federal government, again, the contracting officer can require additional security beyond the act for those payment bonds, similar to the performance bond discretion they have. Next slide. So the amount of the payment bond under the Act has to be equal to the total amount payable under the contract. So that's the amount requirement. However, there's one exception. If the officer, contracting officer awarding the contract, determines, and it has to be in writing, that the payment bond equal to that amount be impractical, then the contracting officer gets to set the amount. However, it can't be less than the amount of the performance bond. So that's one caveat. So essentially, generally, it's going to be in the amount of the contract unless the contracting officer makes an exception. Okay. Now, getting a copy of the bond. We'll go to this next slide. If you're a potential subcontractor claimant, you want to get a copy of the bond. The Act actually provides a process where you can get a copy of that. You have to submit an affidavit that says payments for the work you've done has not been made, and that you're going to sue on the bond. And then what happens is the federal government has to furnish a certified copy of the bond and the contract. Now, that's in contrast to the Little Miller Act, which doesn't have any provision in it that allows for potential claimants to get those copies of those. Typically, if you run into an issue in the Iowa Little Miller Act situation, you can just typically contact the owner and get a copy of it, of the bond and the contract. If you're going to run into resistance on that, you probably have to go through the Open Records Act and get a copy of it that way. So there is a way you can get it in Iowa, but the Federal Miller Act makes it easier and actually provides for a process in the statute. Okay, next slide. There's an exception. So what we just discussed about the general rules of the bonds, if there's a contract of at least $35,000 but not over $150,000, so technically the Miller Act's not triggered, the regulations say that the feds have to provide alternatives to payment bonds to protect subcontractors. And again, as noted here, the Act technically says $25,000 to $100,000, but again, that's been increased for inflation. So even if you're under the Miller Act amount requirement to trigger the Act, there's going to be some alternative provided to protect subcontractors. Next requirement, or I'm sorry, next slide. This is an exception that probably doesn't apply much to those practices in this area, but the federal government can waive the bond requirements if it's a project in a foreign country, if it's impractical to do so. And for certain contracts, the secretaries of the Army, Navy, Air Force, Transportation, and Commerce can waive bond requirements. So again, you're going to have to see what their policies are on that, but they have the authority to do that in certain circumstances. Okay, next we're going to shift gears now and talk about payment bond claimants. Again, this is the main area that we're going to talk about. This is where there's the most litigation under the Miller Act. And what it does, the Miller Act allows essentially the subcontractors who furnish labor materials to seek payment under that bond. Now, note that the claim under a Miller Act is only against the payment bond. There's no claim against any retainage held by the owner, and that is different than the Iowa Little Miller Act, which allows the owner to hold retainage from the prime contractor, and then the claimants can assert a claim both against that retainage and the payment bond. So that's one difference with the Federal Miller Act. Next slide. Now, the courts have limited the scope of permissible payment bond claimants. Essentially, you have to have a contract with the prime contractor or with a subcontractor. Go to the next slide. And that raises the issue of what is a subcontractor, and that can get complicated. Here's a quote from one court case that says it's one who performs for and takes from the prime a specific part of the labor or material requirements of the original contract. That, in my mind, is not a very helpful definition. Still begs a lot of questions. Go to the next slide. But what the courts have generally said is that persons who are supplying labor material to a materialman. So if you have a subcontractor, lower tier sub who's only furnishing materials, now caveat, if that supplier only has a contract directly with the prime contractor, that's not an issue. That supplier can file a claim. But if you're a lower tier supplier, then that's where this is typically triggered. So anybody who's furnishing any labor materials to someone who's only furnishing materials potentially is cut off from a potential claim. Next slide. So there's a balancing test courts use to determine or distinguish between a subcontractor and materialman. So again, I just want you to recognize that the issue of who is what is a subcontractor is not as easy as it might seem. It's complicated. There's balancing test factors that are used. You just have to look at cases in your circuit to see what the law is there. Next slide. Now, notice requirements. There are notice requirements in the Miller Act for certain claimants. However, there's no notice requirement for a claimant who has a contract directly with the prime contractor. So you have a prime who hires a sub or directly hires a supplier. There's no notice requirement for those subs or suppliers. Next slide. But for those lower tier, below those direct subs and suppliers, then there's a written notice requirement. And the notice has to go to the prime contractor. It doesn't go to the owner. It goes to the prime contractor. And that makes sense, because the prime who doesn't have a contract with these potential claimants who are lower tier, the notice has to go to the general contractor. So, so they're on notice that those entities exist and are making a claim. Next slide. So there's deadlines for this notice. The notice has to be given within 90 days of the claimant's last date of furnishing labor materials for which the claim is being made. So as you can see, the deadline varies depending on the claimant at issue. And you have to look and see when was their last date of furnishing labor materials. And as you might imagine, that date can be subject to a lot of dispute. What is the last date? And I'm not going to get into the details of that. Just know that that can be an issue. And the reason it's important is because it can determine whether a notice is timely or not. Failure to provide the written timely notice bars the claim. So if the court determines that the written notice was required, but it wasn't timely given, the entire claim is barred. Next slide. Now, contents of the notice. There was 2002 amendments to the Act, and I'm not going to get into details. I'll just say that it created some confusion and ambiguity on what exactly are the required contents of this notice. So understand there's this issue out there. So if we go to the next slide, my recommendation for claimants is to err on the side of including in your notice the requirements that can reasonably be interpreted in the Act. Okay, so again, this is subject to debate, but to protect yourself against someone arguing your notice contents are insufficient, here's what I recommend. The notice indicate with substantial accuracy. Okay, so you can't just be completely vague. You gotta have substantial accuracy. The following: the material and labor that the claimant furnished the project, to whom those materials or labor were furnished, and the balance owed. Okay, so provide that detail. Obviously, the more detail you provide, the better. If you provide detail that's not required, it's not going to hurt you. So err on the side of providing more detail rather than less is what the takeaway is. Next slide. Now, what do you do with this notice? So you prepare this notice. Who do you send it to? Well, it has to be served. It says delivered in the statute. Delivered to the prime contractor. Okay. Now it has to be delivered to the prime contractor at any place it maintains an office or conducts business or at its residence. Now, the courts have held that this is a means of service issue, and they are much more forgiving and not strict on how the prime contractor gets the notice. So effectively, if the prime contractor is going to gets the notice, even technically, if it's not as outlined in the statute, you probably will be fine, with the caveat it has to be essentially a third party who's going to deliver that notice to the prime contractor. So for example, if a third party emailed the notice to the prime and there was complete evidence they got the notice by the email, you're probably going to be okay, because the courts look, essentially, did some third party, did the claimant hire someone who actually delivered the notice to the prime got it that way? If the answer is yes, you're generally going to be okay. But again, to protect yourself, it's best to comply with what the statute requires so you don't give the other side that argument. So essentially, you hire a process server and serve it that way like you would a lawsuit. That's the safest way. But there's other ways that you can apply. Next slide. Now, there's one thing I just want to notice, let everybody know about, that payment bond claims by unions and by health and welfare trust funds pose interesting notice issues. I'll just alert you to that. For example, a union or a welfare trust fund, often their claims are usually based on labor performed by multiple employees of a subcontractor, for example. And the question is, are all the individual laborers, each individual claimants who in the notice has to be met for each one of those? Or can a union or a trust fund aggregate all these employees into one group, and the timeliness of the notice is measured from that group? That's an issue. Actually, I have a case pending with this very issue in front of the 8th Circuit Court of Appeals. So hopefully we'll get an answer to that question, at least in the 8th Circuit. But understand that issue is out there. Next slide. Okay, now what about statute of limitations to file suit on a claim? There's a reverse statute of limitations, which says a claimant cannot file a lawsuit on a claim until the expiration of 90 days after the claimant's last date of furnishing labor materials. So, if you file or you give your notice within 30 days of your last day of work, you got to wait until 90 days expired before you can sue on that. This is the reverse statute of limitations. Iowa's Little Miller Act has a similar reverse limitations period. It's 30 days after completion and final acceptance of the project. So, the event that has to be met to have that reverse statute expires different under the Iowa Little Miller Act than the federal one. Next slide. Now, the regular statute of limitations under the Miller Act is 1 year after the claimant's last date of furnishing labor material. Now, again, there can often be disputes on what was the last date of furnishing labor materials. And you have to look at the cases on it. That's important because if a court determines that the last date is earlier than what a claimant says it was, that could result in an untimely lawsuit if the lawsuit is filed close to that date. But understand it's 1 year from the last date of work. The Iowa Little Miller Act has a regular statute of limitations too. It's 60 days after completion and final acceptance of the project. So again, the trigger event is different than the federal Miller Act. Next slide. Okay, where do you file suit if you're a claimant? Well, it's in federal court. So the federal courts have exclusive jurisdiction. So you can't bring these in state court. And it doesn't matter what the amount in controversy is. There's no amount in controversy requirement. It's a federal question, essentially, jurisdiction provided right in the statute. As far as venue, it has to be brought in the district court for any district in which the contract was to be performed and executed. So that's the requirements of where you have to bring the suit. Next slide. Okay, and how do you caption your lawsuit? there's a specific requirement in the Act, actually. It has to be brought in the name of the U.S. for the use of the person bringing the action. And I've given an example of how you would caption that. U.S. for the use of John Doe, which would be, John Doe would be the claimant, versus the prime contractor and the surety who furnished the payment bond. So that's how it has to be titled. And but just because it says that, the government's not liable for any costs or expenses. The government's not the one receiving money. I don't know why they require you to title it this way, but they do. But the federal government really doesn't have any involvement in the lawsuit because again, there's no retainage held, or at least there's no claim on the retainage. It's only against the general contractor and its bond. Next slide. Okay, waiver. What if you want to waive, or what if someone waives Miller Act rights? Well, there's restrictions on what can be an effective waiver of Miller Act rights. It's right in the statute. 3 requirements for a Miller Act waiver to be effective is it has to be in writing. It has to be signed by the claimant. Okay, so you can't have verbal waivers. You can have some written waiver that's not signed. It has to be in writing, it has to be signed, and importantly, that signature in writing, that signature of that written waiver has to be executed after the claimant has furnished labor and materials on the project. So, for example, if you're a prime contractor and you include in your subcontract a waiver of a Miller Act, and they sign that subcontract before they start work, it's not effective. It has to be essentially a separate waiver signed after the claimant has already started work. In contrast, Iowa's Little Miller Act does not have any kind of special or specific waiver requirements for effective waivers of the Little Miller Act rights. Next slide. Okay, that's everything. I think we are out of time. We're right on time.
Well, thank you so much, Stephen. I really do appreciate it. That was pretty incredible. And thank you for making the distinctions between the Federal Miller Act and then the Little Miller Act. Those are definitely things that we need to be on the lookout for. So we appreciate that. I do have a question that came through. It says, can an unlicensed contractor file an Iowa mechanics lien?
So the question, okay, can an unlicensed contractor, I'll interpret it this way. As the question is, if a contractor, if an entity, let's say, but has to be a company, is not, does not have a certificate of authority to do business through the Iowa Secretary of State. Okay, so in Iowa, you have to be registered to do business, and you do it through the Iowa Secretary of State. They have requirements for Iowa companies, and then they have requirements for foreign companies, namely those headquartered outside of Iowa. So you have to be registered, and the Secretary of State issues a certificate of organization or authority to do business. If you don't have one of those, there's a statute in Iowa that says you cannot maintain any action or take any action. So the short answer is I guess you can file the lien or the claim, but it's not technically going to have any effect. However, the statute says you can retroactively cure that by going in and registering and getting your certificate, and then it cures all the past things you did when you weren't registered. So I guess the answer is no, technically you can't, but you can easily cure it if the issue comes to your attention.
Okay, perfect. Thank you. And then another question that just came in is, can attorney's fees or filing fees be included in the lien amount, or I guess in the lawsuit if it came to that?
Yep. So good question. So the Miller Act itself, and this I'll say it's a confusing area of federal Miller Act law. The Miller Act itself does not give any claimant the right for attorney fees. Okay, so if a claimant is requesting attorney fees and their basis for that is the Federal Miller Act, the answer is you're not going to get attorney fees. There's no basis because the Miller Act applies the American rule, which says each side pays their own attorney fees. However, if a claimant has a contract or subcontract that allows it to recover attorney fees, then they potentially can recover attorney fees. However, there's an issue within that. Let me explain. If a prime contractor has a subcontract with a subcontractor that provides the subcontractor can recover attorney fees, and then that subcontractor files a Miller Act claim, that subcontractor claimant can recover attorney fees under the Miller Act because its subcontract provides. However, if you have a lower tier subcontractor who doesn't have a contract with the prime contractor and their subcontract also provides for attorney fees, it is unclear whether or not they can recover attorney fees. That 8th Circuit case I mentioned earlier that I have pending right now, that is one of the issues. Our position, I have the general contractor, and the claimant is a health and welfare trust fund who we don't have any contract with that entity or with their employees. And so our argument is that they can't recover attorney fees because they have no contract with us that provides it. And so it's unclear right now. So I apologize for not giving a exact answer on this, but the answer is it's unclear. But I can tell you if the claimant has a contract directly with the prime and that written agreement has an attorney fee provision, that claimant can recover attorney fees. Lower tier claimant, it's unclear.
Okay, great, thank you. And then one other question that I see came through, it says, what are some alternatives for suppliers to file if the contract is under $35,000?
So if you're under 35, so I think that refers to the fact that I think we looked at the slide that said if you're under the Miller Act trigger amount of 150, but you're within 35 to 150, there's alternatives. What if you're under 35? The answer is there's no requirement in the act that the feds provide anything to protect those lower tier subs. However, the feds can require it if they want. So my answer would be take a look specifically at the agency of the project and ask, is there anything that a bond or any other security on this project that would cover us? There might be. Now keep in mind, if you're a sub and your amount is under 35, if there's still a bond provided because the contract's $10 million, even though your piece is under 35, you're still covered by that bond. You can still file a Miller Act claim. The only issue is if you have a project where the amount is under 35, what happens to those lower tier subs? And that's what I'm talking about here is you got to check. If there isn't any security, then you're left with just a straight breach of contract claim against whoever you're contracted with. So that would be your only remedy if there wasn't any security.
Okay, well, thank you. All right, so if that answered your question, wonderful. If not, please reach out to us. If you have any other questions that weren't addressed, please feel free, reach out to us, either myself or to Stephen, and we will be sure to answer any questions for you. Let me get to the next slide for us. All right, so we are going to test a little bit of your knowledge. Let's see if you guys can answer correctly. So we have a little bit of a pop quiz. If you're able to answer correctly and put it into our chat, we will send out a little gift for you guys. So the first question, in Iowa, if a subcontractor or supplier fail to send a preliminary notice as soon as possible on residential projects, what is the consequence for that? So take a look at those answers, see if you think you know it. And then the second question, on a commercial project, when is the deadline to file an Iowa notice to general contractor or owner builder for a subcontractor or supplier? Again, if you think you know those answers, go ahead and write it in the chat or the questions area, and we will send you over a little gift if you guys have won that. All right. Okay, so here are some of our SunRay resources to help you guys stay organized, know your deadlines, and be able to secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's plenty more available through our site that we are able to offer you guys and make sure that we're getting you guys your money that's owed to you for your work. All right, so we have a new service with SunRay. We have SR Receivables. It is our collections company that we are going to be working for you to help get you guys your money of what's owed to you. All right, let me get back over here if I can. There we go. All right, the next webinar with Stephen is going to be on Thursday, June 13th at 11 a.m. Eastern. So please go ahead and register for free at sunraynotice.com/education. So that way we can make sure you're a part of it and get to hear some more information there. All right, and then on this slide, if you guys don't mind, scan that QR code, give us a review on Google. It helps us learn from you guys on your feedback and make sure that more contractors are hearing about us and getting this information to them. Okay, and with that, that is all we have for you guys today. Thank you for everybody who attended. Thank you so much, Stephen. You were incredible. Thanks so much for answering all those questions. And we hope everybody has a wonderful, wonderful day and a happy sunny day. Have a good one. Bye-bye.
Thanks, Jesse. Thanks, everyone.